Today we'll be talking about employment-related laws, specifically the basics of these laws and what the HR team wants you to know. Here's the agenda for today. We're going to start with an overview of employment laws, where we'll be defining what employment laws are, as well as explaining some details of the presentation and setting expectations. After the employment law overview, we'll dive right into discrimination and harassment. The laws we'll be covering there include Title VII of the Civil Rights Act, the Age Discrimination and Employment Act, the Americans with Disabilities Act, and the National Labor Relations Act. We'll then pivot over to protective leave laws. These include the Family and Medical Leave Act, the Uniformed Services Employment and Reemployment Rights Act, and then we'll speak on compensation and overtime laws. These include the Fair Labor Standards Act, the Equal Pay Act, and the Employment Retirement Income Security Act. And finally, we'll be speaking about safety and layoff laws, which include the Occupational Health and Safety Act, as well as the Worker Adjustment and Retraining Notification Act. So what are employment laws? Employment law is a section of U.S. law that determines how an employee and an employer can work together. These laws were designed to regulate the relationships between workers and managers to ensure that everyone is treated fairly and respectfully. The laws could include anything from what workers should be paid, how and when an employee can work, minimum workplace safety conditions, when someone can be hired or fired, and equality in the workplace. Before we get into the bulk of the slides, it's important to note the breakdown of each slide. Each slide detailing laws will have three things on them: the law's historical background, legal information, and the company's expectations. The historical background is self-explanatory. It will include details on the law's history and why it was created. The legal information will include the important legalities of each law and what we think you should be aware of. And the company's expectations are what we expect you, as a new manager, to do to make sure you're adhering to the law in order to protect the company. With that covered, let's talk about discrimination and harassment laws. Let's begin with Title VII of the Civil Rights Act. Before Title VII of the Civil Rights Act, there was rampant discrimination in the workplace. Employers could decide whether or not to hire, promote, or extend benefits based solely on the way candidates and employees look or believe. To counteract that, in 1964, President Lyndon Johnson signed Title VII of the Civil Rights Act into effect. This brought with it a slew of changes in the workplace and made it illegal for companies to discriminate against candidates and employees on a variety of different factors. However, it wasn't until the implementation of the Equal Employment Opportunities Commission, or the EEOC, did the U.S. see a large amount of inequality lawsuits. The EEOC essentially gave Title VII teeth. As mentioned, Title VII made it illegal to discriminate based on a variety of different factors. These include color, race, religion, sex, or national origin. You cannot reject an applicant, decide whether or not to promote, determine pay or benefits, harass or discriminate based on color, race, religion, sex, or national origin. Companies' expectations. It is imperative we follow the guidelines set by Title VII. In 2019 alone, the EEOC had received 72,675 charges of workplace discrimination. Some of the ways that we could protect ourselves are by treating every job applicant the same, and specifically making sure that you ask the same questions to each job applicant. Keep personal topics out of the conversation and keep it professional. We'll be implementing mandatory yearly harassment training for all employees. These classes will be separated by employees and managers. Employees need to know how to recognize harassment and how to properly file complaints internally. Managers need to be aware of what harassment looks like and how to avoid it. Further, managers need to know how to properly handle any complaint that comes to them. Finally, when receiving a complaint, it must be delivered to Human Resources for further action. Do not try to handle the complaint by yourself or stop the complaint from escalating. The Age Discrimination in Employment Act was created to help combat arbitrary age limits in the workplace. It was common for employers to impose certain undefined age limits on roles, and it was also common for candidates and employees to be discriminated against due to age. The Age Discrimination Act bill was signed into effect by President Lyndon Johnson in 1967. Initially, the Age Discrimination Act protected employees and applicants aged 40 to 65. This limit was later amended to include all ages in the workplace, and it also ended mandatory retirements for nearly all workers. The ADEA forbids discrimination against people who are of the age 40 or older. The ADEA also prohibits discrimination due to age in any of the aspects of employment. These can include hiring, firing, pay, job assignments, promotions, layoffs, training, and benefits. It also makes it unlawful to harass an employee due to their age. This generally includes harassment that is so frequent or severe that it creates a hostile work environment. It also includes when it results in an adverse employment decision. And finally, this law applies only to companies with 20 or more employers. So company expectations. It's important to maintain a diverse workforce, including employees that are older than yourself. It can be easy to hire people who are similar to you, but to avoid potential litigation, again, it's important that your team are made up of a variety of different backgrounds. Just like in the expectations for Title VII, it is important that we keep standard interviews and ask every candidate the same question. Avoid questions about a candidate's birthday or graduation date. Don't ask any questions that are not necessary to the job function. And do not assume that an employee is ready for retirement due to their workforce longevity. Know that you cannot force an employee to retire, and asking questions around that is actually off limits. The history of the Americans with Disabilities Act started long before the introduction of the bill to Congress. People with disabilities began to challenge societal barriers that excluded them from the workplace by establishing local groups to advocate for equal rights. This eventually led to the Americans with Disabilities Act being introduced to Congress in 1988. It was subsequently passed in 1990. An amendment to the ADD, called the Americans with Disabilities Act Amendments Act, or the ADAAA, was signed into law in 2009. The ADAAA made significant changes to the definition of disability, generally making it easier for people with disabilities to seek protection under the ADA. The ADA prohibits discrimination against individuals with disabilities. This includes all areas of public life, such as jobs, schools, transportations, and all public and private places that are open to the general public. Essentially, the goal of the ADA is to make sure that people with disabilities have the same rights and opportunities as everyone else. In fact, the ADA gives civil rights protections very similar to those provided by Title VII. It guarantees equal opportunities for those with disabilities in 5 different areas. These areas are split into 5 different titles of the ADA, and they include employment, state and local government, public accommodations, telecommunications, and miscellaneous provisions. Companies' expectations. The ADA requires that we avoid using a one-size-fits-all approach to dealing with employees with disabilities. It's important to take in consideration each worker individually and their situation. In fact, 10% of people in the US are living with a disability that isn't immediately visible. Don't assume just because you can't see a disability doesn't mean that the worker or applicant doesn't have it. So make sure to treat any employee that mentions a physical or mental condition that could impact their work according to all ADA guidelines. And as always, be careful during job interviews with candidates. While some roles do have necessary physical requirements, only ask about the necessary requirements and avoid any unnecessary questions. The early 1930s saw workers begin to start to organize and collectively bargain on a large scale. Subsequently, employers began to spy on, interrogate, discipline, and even terminate employees that were organizing. This led to a great wave of strikes in 1933 and 1934 in the form of citywide general strikes and factory takeovers. There were even confrontations between workers and employers that turned violent. In response, the National Labor Relations Act was passed and signed into effect by President Franklin Roosevelt in 1935 to guarantee certain worker rights. The NLRA gives employees the right to engage in union activities without being retaliated against by their employer. These guaranteed activities include forming a union, joining a union, assisting a union in organizing fellow employees, or to be fairly represented by a union. Employees who are not represented by a union are still guaranteed rights under the NLRA. These protected rights include concerted activity, or more than one employee taking action for their mutual aid or protection. Examples of this could include two or more employees addressing their employer about improving pay, addressing safety concerns, or improving workplace conditions. Most employees in the private sector are covered by the NLRA. The exceptions are federal, state, or local government employees, agricultural laborers, independent contractors, and those employed in domestic service. So companies' expectations. It is against the NLRA to encourage or discourage membership in any labor union. Be careful about how you treat employees who are supporting, engaging in, or starting a union, as you are not allowed to retaliate against employees who are doing any of these actions. Retaliation can include terminating, suspending, laying off, demoting, or disciplining these employees. Like mentioned, even employees who are not in unions still have rights. They are allowed to discuss a variety of different things, such as their pay and workplace conditions, without being retaliated against. Next, we'll be speaking about protected leave laws. Prior to the Family Medical Leave Act being signed into law, it was common for women to routinely lose their jobs when they took time off to have a child. This resulted in limited career prospects for women and even endangerment of their health by returning to work too soon. The FMLA was proposed to provide means for employees to balance their work and family responsibilities by being able to take unpaid leave for certain reasons. And the FMLA was signed into law by President Bill Clinton in 1993. The Family Medical Leave Act entitles eligible employees 12 work weeks of unpaid leave for the following: birth of a child and to care for the newborn, adopting a child or fostering a child, caring for an employee's spouse, child, or parent with a serious health condition, or a serious health condition that makes an employee unable to perform essential job duties. In order to be eligible to take and be protected under the FMLA, an employee must meet the following criteria. They must work for a covered employer, have worked 1,250 hours during the 12 months prior to the start of leave, work at a location where there are 50 or more employees, and have worked at the employer for at least 12 months. FMLA protects these employees by guaranteeing their job or an equivalent job is waiting for them when they get back. This means that employers cannot fire someone who is taking FMLA leave. If an employee is provided group health insurance, the employee is entitled to the continuation of the insurance on the same terms as if they had continued to work. So companies' expectations. If an employee is taking FMLA leave, you are forbidden by law to terminate them. They are protected under the FMLA, and we must guarantee their job for them. If they are in a job function that is deemed business critical, then it is okay to replace them. However, upon an employee's return, they must have an equivalent job waiting for them. An equivalent job means that it is virtually identical to the original job in terms of pay, benefits, and other employment terms as location. The Uniform Services Employment and Reemployment Act, or the USERRA, isn't the first piece of legislation that was designed to provide employment and reemployment for members of the armed services. The USERRA was actually a complete rewrite of the Veterans' Reemployment Rights and was passed in 1994. The USERRA was created with the intention to minimize the disadvantages that armed service members experience in the workforce. These disadvantages can occur when armed service members are required to take extended leave in service of the country. The law covers virtually every individual that serves or actually has served in the uniformed services. The law ensures that those that serve their country can retain their civilian employment and benefits and can seek employment free from discrimination because of their service. So companies' expectations. If an employee has to leave due to military service requirements, know that their job is secure. Much like the FMLA, you can fill their role, but when the employee comes back, an equivalent job must be provided. Again, an equivalent job is the same pay, benefits, and other employment terms like shift and location. And please do not discriminate against an employee due to their armed service. Now we'll take some time to talk about compensation and overtime laws. The Fair Labor Standards Act was enacted over 80 years ago with the intention of improving working conditions in the U.S. Before the act, there were very few legal standards over things like minimum wage, workweek hours, age requirements, and more. The FLSA was signed into effect by Franklin Roosevelt and is widely considered to be the last major legislative accomplishment of his New Deal. The laws changed over the years as the U.S. workplace landscape has changed. As of right now, it has had over 20 amendments or additions. These additions included raises to minimum wages, changes in overtime pay, and more. The Fair Labor Standards Act established a variety of different things. These include minimum wage, overtime pay, record keeping, and youth employment standards. FLSA minimum wage is currently set at $7.25 per hour, and this was effective July 24, 2009. FLSA overtime is currently set at 1.5 times the employee's regular hourly wage for any hour worked over 40 per work week. FLSA set laws around child labor to help protect the education opportunities of minors and prohibit their employment in jobs. The ages vary by state, but as a general rule of thumb, no child under 14 years old is allowed to work. And finally, under the FLSA, employers must display an official poster outlining the requirements of the Act. So companies' expectations. Make sure that all wages are above $7.25 per hour or the minimum wage set by our state. Make sure all employees are correctly documenting their hours, and if employees are working over 40 hours a week, make sure that they are being paid at time and a half. Check your work area to ensure that there is an official poster displayed that outlines the FLSA laws. And make sure that all your employees are above the minimum age of 14 or the minimum age of our state mandates. The Equal Pay Act was one of the first federal anti-discrimination laws that addressed the wage differences based on gender. Prior to the Equal Pay Act, men and women could earn unequal pay for what was considered equal work. The Equal Pay Act was in the works for almost 100 years. Many similar bills were submitted to Congress just to be shot down somewhere along the way. To combat pay inequality, the EPA was signed into law by President Kennedy in 1963 as an amendment to the Fair Labor Standards Act. The Equal Pay Act established what is known as equal pay for equal work. It requires that men and women in the same workplace be given equal pay. The jobs don't have to be identical, but they have to be substantially equal. If the job content of two positions are equal, then the pay between a male and female worker must be equal as well. The Equal Pay Act covers all forms of pay. This includes salary, overtime pay, bonuses, stock options, vacations and holiday pay, allowances, and more. Title VII also makes it illegal to discriminate based on sex and pay. So those that have an Equal Pay Act claim may also be able to claim discrimination under Title VII as well. So companies' expectations. Finding what is considered an equal job can sometimes be tricky. Since job equality is based on job content, make sure that you identify which jobs can be equal by reviewing every job's responsibilities. Make sure that the men and women in equal jobs are being paid equally. Do not discriminate in any form of payment. Make sure that men and women in equal jobs are being paid equally all across the board, including overtime benefits and more. The Employee Retirement Income Security Act, or the ERISA, was signed into law by President Gerald Ford in 1974. It was enacted to address public concern that funds of private pension plans were being mismanaged and abused. The goal of the ERISA was to protect the interests of participants and their beneficiaries in employee benefit plans. The ERISA sets the minimum standard for most voluntary established retirement and health plans in the private industry. It sets standards for things such as participation, vesting, benefit accrual, and funding for these plans. The ERISA also requires that plans provide participants with information about plan features and funding. And finally, the ERISA covers almost all private sectors, but does not cover plans established by the government or churches. Company expectations. As the ERISA sets minimum standards on plan providers, there is little that the company expects you to do. Just know that the ERISA does not require our company to offer benefits. Finally, we'll take a look at safety and layoff laws. Before the creation of the Occupational Health and Safety Act, or OSHA, there were no US-wide safety standards. These lax safety laws led to a lot of workplace injuries and fatalities. OSHA was established in 1971 to set safety standards nationwide. These standards include training, compliance assistance, and health and safety recognition programs. Since enacted, the American workplace has seen a steep drop in work fatality and injury rates. Since the passage of OSHA, serious workplace injuries have declined from 11 per 100 workers in 1972 to 3.6 per 100 workers in 2009. OSHA requires that employers provide their employees with safe working conditions. To help assure a safe and healthy workplace, OSHA provides workers the right to receive information and training about hazards, and request OSHA to inspect their workplace. Further, employees are allowed to observe the testing and inspection being done by OSHA. These rights are guaranteed under the law and ensure employees are free from retaliation. OSHA covers most private sector employees in the nation. State and federal government workers are not covered, but their agencies must have health and safety programs that are equivalent to OSHA's. Company expectations. Provide your employees a safe and healthy workplace by adhering to all OSHA regulations. Encourage your employees to take OSHA safety courses if they aren't already. As a manager, it's important for you to know OSHA standards as well. If you don't, consider taking refresher courses. Employees are guaranteed these aforementioned rights under OSHA, so do not retaliate against an employee for requesting OSHA rights. The Worker Adjustment and Retaining Notification Act was enacted in 1988 and became effective in 1989. The WARN Act was created to protect employees who, through no fault of their own, are let go by their employers. WARN specifically focuses on layoffs due to company closures, and in fact, WARN was passed in large part due to the growth in offshore outsourcing of companies in the 80s. The WARN Act requires that employers with 100 or more employees provide a WARN notice to all employees, including supervisors and managers, if the business is shutting down. Employers must provide a 60-day notice in advance to the business shutting down, plant closure, or mass layoffs, including 50 or more employees. The employer does not have to give notice if the closure is due to unforeseeable business circumstances. These circumstances can include dramatic downturns in the economy, unexpected termination of a major contract, or losing a major supplier. Company expectations. Since the employer is required to let all employees know of the business or plant closure and layoffs, the company has no expectations of you as manager. Thank you so much for your time today. If you have any questions, we'll have a few minutes to answer them. And as always, feel free to contact HR with any follow-up questions or concerns.